So can you let me know when you've moved us over, just in case if there's no participants, I wouldn't know.
Okay, we are good now.
Okay, all right. Good afternoon, everyone, and welcome to the LACIAC live debates. We're just going to give 2 more minutes for any additional participants to join, and we will be starting at exactly 2:05. Thank you. Hello, everyone. I see we have 37 participants on the call right now, and so we'll just give 3 more minutes and start at 2:10. Thank you so much. So we'll be starting the debate now. Thank you so much for joining us. Welcome all. It's a great privilege and pleasure to welcome you all to the 9th edition of the LACIAC Live Debates. We launched the first edition of the live debate in July 2020, and we've lived up to our objective of maintaining the debate as a continuous series. We've had 8 successful editions to date, so this is our 9th edition of the debate. The debate focuses on developing and emerging trends and issues within the international arbitration community, and to provide a platform for arbitrators and arbitration practitioners to discuss these issues. We're grateful to those of you who have been with us from our very first edition to this, our 9th. If this is your first time, we are also very glad to have you, and we hope that it will not be your last. Over 100 people from different regions in Africa and Europe and all over the world have registered their interest to attend this event, and so I expect that it will be a lively and thought-provoking session. My name is Ife Omotola. I am going to be your moderator for today's event. I am a senior associate at ALN Nigeria, Alukwano Yobode, and I'm also a volunteer counsel at LACIAC as well. Before we start our debate, I will introduce our debaters and also just give a brief background on our debate topic. So our first debater, who will be proposing the motion that the state's right to regulate should never give rise to compensation of foreign investors, is Aisha Abdallah. Aisha is a partner at ALN Kenya and Jawala and Kana, where she heads the Regional Dispute Resolution Department based at the Nairobi head office. She's dual qualified as an advocate of the High Court of Kenya and a solicitor of England and Wales. She has substantial experience in complex, high-value cross-border disputes. She was nominated by the Kenyan National Chamber of Commerce to the board of the Nairobi Center for International Arbitration in 2021. In December 2022, she was appointed to join the governing council of the Hong Kong International Arbitration Center and is a member of its proceeding committee. She also sits on a number of other international arbitration bodies, including the LCIA Africa Users Council. She was the lead author of the Kenya chapter of the 6th, 7th, 8th, 9th, and 10th editions of the International Arbitration Review. She also specializes in economic crime. She's the Officer for Africa at the IBA Asset Recovery Committee and was part of an expert team that drafted anti-money laundering, remittance, and mobile money bills for Somaliland. She was the lead author of the Kenya chapter of the 2018 Chamber's Anti-Corruption Global Practice Guide and the ALN Anti-Corruption Guide 2019. She's passionate about the rule of law. I mean, clearly, she has given up her time to be here to educate us on arbitration and the impact of quality legal training on raising professional standards. In September 2023, she was appointed as the Law Society of Kenya representative to the Council of Legal Education. She's a director of the ALN Academy, a charity that provides legal training and capacity building to public and private sector lawyers in Africa. Aisha is also the patron of ALN Kenya Pro Bono Committee and a member of the governing council of the Pro Bono Institute of Kenya. Aisha is recognized by both Chambers Global and Legal 500 for disputes. Before I move on to introduce Obioma Ofuego, I just want Aisha to just say hello to all of us.
Hi, everyone. Nice to see you, or not see you, but to be seen.
Thank you so much, Aisha. Now moving swiftly on to our next debater who shall be opposing the motion that the state's right to regulate should not give rise to compensation for foreign investors. Obioma Ofuego is a senior associate in Quinn Emanuel's Paris office. He joined the firm in 2020. He specializes in international commercial arbitration, investment arbitration, and public international law. Prior to joining the firm, he worked as a barrister in independent practice in London, as an assistant legal advisor at the Foreign and Commonwealth Office, and at another leading international law firm in Paris. He has acted in arbitrations conducted under the auspice of various major institutions, such as ICSID, the ICC, and SCC, as well as in ad hoc arbitrations conducted under the UNCITRAL rules, and has appeared as an advocate before international tribunals, as well as the English courts. Before coming to the bar, Obioma has quite a lot of experience under his belt. He also worked at UNESCO Paris in the field of education and cultural policy, and as an academic in African literature, and has authored a number of books. He's fluent in French, Spanish, Italian, and of course, English, which is what he will be speaking to us today. So Obioma, if you could just briefly say hello as well.
Hi, everyone, and hi, Aisha.
Hey, thank you all so much. So we are about to start the debate, which is on the motion that the state's right to regulate should never give rise to compensation for foreign investors. Before I introduce the debate, just a few housekeeping rules, just to let you know that Ms. Abdallah and Dr. Ofuego have given their time today to speak to us, and they have been assigned a position on the topic. These are not their personal opinions, neither are they necessarily the position of their firms or their clients as well, as we are obviously all used to such rules in debates. And so it's definitely going to be an interesting intellectual exercise. As well, before we commence the debate, after I introduce the topic, we will have a poll where we will have an opportunity to indicate whether we agree or we disagree with the debate motion. And then afterwards, after a Q&A session, we will also have another opportunity as well, just to see if our debaters manage to shift the needle in any kind of way. The debate will be approximately 40 minutes. Aisha proposing the motion will have 15 minutes. Obioma opposing the motion will have 15 minutes. They will then have rebuttals of 5 minutes each. Afterwards, there will be a Q&A session of 10 to 15 minutes, depending on how many questions we get. After that, our debaters will have an opportunity to give us a final address, to say any last words that they have on the topic or anything that they feel strongly about the topic, which they did not have an opportunity to say during their debate. And afterwards, I will give a few closing remarks on behalf of LACIAC. Now, why did we decide to talk about the right to regulate today, which we thought was a very topical issue in the area of investment arbitration? The right to regulate is usually a customary right of any sovereign state. It's their right to legislate, their right for regulatory freedom, regulatory space, police powers, prescriptive jurisdiction. And this basically states that a state possesses an inherent right to regulate, to protect its public interest, and does not act wrongfully when, pursuant to that power, it enacts its right to make laws in accordance with due process. Due process is a very important element, which I'm sure is going to come up in both in the proposition and the opposition of the motion. Now, where this sometimes intersects with investment arbitration is where the state's right to regulate clashes with investment arbitration treaties that may have been made previously, and as such affects the investor's rights. And so today's topic is that when the state, in accordance with due process, exercises its right to legislate and to regulate, should that ever give rise to compensation to foreign investors in investment treaty disputes? That's all I'm going to say on the topic, so that I don't indicate a bias either which way. And I will then cede the floor to Aisha to give us her 15 minutes of proposing the motion.
Thank you so much, Ife, for setting the scene. Just to begin with, you've been told the right to regulate is an emanation of each state's sovereign right to take necessary actions for the benefit of the public interest and for their own citizens, and to respond also to changing times. So the first thing I'd like to say is that as we look at this issue, we're on the one hand balancing some obligations made by host nations under international investment agreements with another set of obligations. And these obligations are positive. So as much as we talk about a state's right to regulate, actually many jurisdictions like Kenya, under our constitution, there's a positive duty for a state to take action to prevent harm. And this is a concept that you would readily understand in other jurisdictions also applies. So it's not simply a right to regulate. They can actually be sued before our constitutional courts and made to enact measures to address a public interest issue that arises. And so we need to frame it appropriately, because often we are talking about contractual obligations or treaty obligations, but also there's a whole other set of treaty obligations that I'll come to later, which actually have the same status or potentially a higher status. And often these arise from things like the Paris Treaty, where the whole world came together to say we're going to jointly undertake measures to combat climate change. So I just want to give you that context so you don't think of it as a straightforward legal issue. It has many parameters and ramifications. So why is it important that states are given the necessary freedom they require so that they are able to regulate and respond? The first is simply a basic question. A basic point, which is that often these investments are long-term. So you will find that a lot a lot of mining concessions, oil and gas exploration. These are long-term contracts, and they take place and are negotiated within a certain set of circumstances. And then you will find 10, 15, 20 years down the line, actually so much has changed in the world. There might be conflicts in the world, like the Ukraine war. There might be changes in public perception about certain issues, like public health issues. There might be an increasing concern about things like climate change. And therefore, a state's laws can never be static. So I think we would all understand as citizens and nationals of our own countries that a state, by definition, in order to meet its obligation to its citizens, would be required positively to take steps to respond to emerging issues, to respond to new data, emerging trends, and to positively take steps, some of which are likely to interfere with foreign investors and their investments. So, obviously, these have an impact. The question is, that impact, given that a host state always has the right to legislate within its jurisdiction and impose laws that apply to everyone, foreigners and and locals, to what extent should any of these measures taken by states attract compensation? My argument is that the very nature of a state's duty to legislate has, in multiple decisions around the world, been considered essentially to be almost non-justiciable. So often you will find courts in our jurisdictions in the common law drawing a line and saying, we can interrogate an executive action and decide if it's legitimate, if it's valid. But it is not our role as courts to step into the arena and essentially impose some legislation. That is normally in our states, because in Kenya we elect our members of parliament. That is a role that under our democratic system is reserved to another sphere of government and actually is not necessarily justiciable. So bearing that in mind, there must be some measures that we would all agree probably should attract compensation and aren't actually a legitimate exercise of this power. I think the problem is that the assumption in the older case laws, and I do warn people not to rely heavily on cases that took place maybe 20 years ago, because I think we have seen a development in international law and an understanding that the previous cases were essentially decided on the wrong basis. And what is that basis? The previous cases seem to have this doctrine called Soll effects, where they simply assessed the impact on an investor of a particular form of regulation, and they didn't look at the purpose. What was the purpose behind that specific regulatory measure? They simply looked at, this is the state of play at the time the investment was made, and then there was a change, and therefore, let's just look at the impact. Obviously, most of those impacts were adverse, and then they would issue compensation awards, and these were often very large awards. And this is problematic politically because often those were foreign investors coming from the global north, investing in the global south, and these huge awards had this impact of undermining the overall ability of a state to meet its basic obligations like public health, like providing clean water, like providing basic education, and all these other things that states must provide, simply because of the quantum. So there was then a gradual move. So then they came up with this new concept, which has been touched upon, called police powers, where they would look at the measure and determine if it served a legitimate public purpose. What is the reason behind this measure? Is it non-discriminatory, or is it targeting that specific foreign investor, which would obviously not be good? And is it enacted in good faith? And essentially, this was because it was perceived that there had been too much of a trend towards a pro-foreign investor type of consideration, and they were trying to rebalance. I will come later to this idea. Is it actually open to a private tribunal to itself determine what is a legitimate public purpose, given that these tribunals often sit very far away from the host states? And honestly, are likely to have a very different definition of good faith, but we'll park that for the time being. And then there was a subsequent evolution, and they came up with this doctrine called proportionality. And it's this idea, which we're familiar with in other legal dilemmas, where you have to balance public interest against the impact on the investor. So both have weight, but what is the exact weight to be attributed in a particular circumstance? And we see this evolution in the case law because there was a case called Metaclad versus Mexico in 2000, which essentially applied the sole effects doctrine and was decided in favor of the investor by solely focusing on the impact. And then we have what I would call the high watermark currently, which is the Philip Morris case versus Uruguay in 2016. And this Philip Morris case, it concerned Uruguay's right to legislate in order to protect public health. So the claim was brought under the Switzerland-Uruguay bilateral investment treaty, and it touched on the ability of Uruguay to restrict tobacco companies like Philip Morris. So basically they imposed a new restriction, which was that they could only sell one variant per brand, and also that 80% of the packaging had to be covered with these health warnings. So you can imagine that Philip Morris spent a lot of time and money branding, and then 80% of that is taken up with a very ugly warning that is basically telling you don't buy the product. So they brought this claim. And Philip Morris said, look, this is essentially expropriation, and it's not fair and it's not equitable. So we're entitled to compensation. What the government of Uruguay argued, and there was a lot of data by that time, it's 2016. We've had studies about the effects of smoking leading to cancer and other impacts on public health care for so many decades. So by then, there's a lot of data. And they said states should be given a wide margin of appreciation in order to determine for themselves what measures are appropriate. And, public health, it's a key issue. And so if you think about it, if those health warnings were not in place, maybe more people would take up the product and then they would become a burden on the public healthcare system. So there are many things that needed to be weighed up. In any event, the tribunal dismissed the claim by Philip Morris. They said this is not expropriation because Philip Morris was still allowed to sell its products within Uruguay. So it's not that the products were illegal. They were legal products. They could sell them. They simply had to comply with the restrictions. And what they did say also was that Philip Morris could not have had a legitimate expectation that the regulation of tobacco products would remain the same because by this time there were well-documented health risks of tobacco and there was an international trend towards stricter regulations. So I call that the high watermark because I think this is an industry issue where you have a lot of data. It supports the view that essentially there are severe consequences of cigarette smoke, and they don't just impact the individual, they do impact the wider society, and they have an impact on public healthcare budgets. And these studies are supported by the World Health Organization. But we also see that tribunals, and by their nature, remember, these are not elected officials. They're not in any way close to the host state. They are struggling with balancing this concept of right to regulate an investor interest. So there's a case called Eco Oro Minerals versus Colombia in 2021. And this was a Canadian company that had a mining concession in Colombia. And what happened was there was a Canada-Colombia Free Trade Agreement. So some measures were taken by the Colombia government. They were essentially to protect a particular area, which is called, and I'm sure I'm mispronouncing it, the Paramo. So it is a distinct geographical area, and it was critical for biodiversity and water conservation, that specific area. Anyway, so they took measures, and essentially this meant that the investor could not proceed with its planned appropriations, and it brought this claim for $696 million, saying that essentially these actions taken to protect biodiversity and the environment had harmed its investment. And it was quite clear that the regulations were taken in good faith and in the public interest. So the tribunal said this is not expropriation, but what it is is it is a breach of fair and equitable treatment, and that the delay in the government demarcating this specific area was led to a lot of uncertainty, and because the government had not been consistent in protecting that area. And so the tribunal said this did deserve compensation. So I think here, there are a whole bunch of cases I could talk about, but I'd like to come back to something I mentioned, which is, this type of system where you're essentially donating a power to a private tribunal that sits outside the state, that has no relationship and no legitimacy to those nationals. You're giving them all this power to consider public policy and whether something is in good faith. I think in itself deserves interrogation, because it seems to me that it lacks a lot of legitimacy. And because of this, you will find that there has been increasingly a push to essentially amend a lot of bilateral investment treaties and to have more modernized treaties which are codifying the right to regulate and essentially trying to rebalance and give states more power directly. But also there's a move by a lot of, for example, African states to move away from this whole system of investor-state disputes, because it is seen to be unfair. Now, one thing I wanted to point out, we often might think as Africans that these are issues where you always have a Western foreigner investing in an African country, but actually these issues also arise in very sophisticated jurisdictions. Spain have had a whole host of claims made against it, because at one point Spain provided a very favorable environment and tax incentives to encourage foreign investors to essentially invest in solar energy and renewables. And then this was in 2007, and then 3 years later in 2010, it removed one of the subsidies and imposed a tax. And they faced a lot of claims. But remember what I said, that these treaties and these investments are negotiated within a certain commercial, political, and holistic environment. And often you will find in the world that changes. And we are going through one of those periods at the moment. We're going through a period of great uncertainty. And essentially, we've seen with the election of a new president in the US that we even have, it's affecting many other people than just the electorate in the US, because we're seeing the United States potentially withdrawing from international treaties, potentially withdrawing from the Paris Treaty and other organizations that we thought probably we had this idea that those things were quite stable. So each state will always react based on its own idea of what is in its public interest. And of course, by definition, if you have a democratic election, that concept of what is right and what is fair is going to change. There's no way you could legitimately say as an investor, I have a 20-year life cycle to operate my plant, and I expect everything to remain the same. I think all that remains the same is change. And so I have to finish now, but I just want to remind us of the way I started this, and I framed this in this way. We're balancing obligations under international investment treaties with other obligations that are either of the same status or higher. And a very good example of this is the Paris Treaty, which is an international treaty signed by so many states. And what it requires the whole world to come together to combat and mitigate the effects of climate change. It's not going to be possible for any one state to combat this on its own, because the effects are global. And yet we are finding that the ability of states to meet Paris Treaty obligations and mitigate climate change is being adversely impaired and impacted by pre-existing obligations to foreign investors. Now, I would just leave you with this question. Where you have to balance these interests, whose interests should be supreme? Should we take a foreign investor and say that their interests override the global interest in climate change? Or is there another order, another hierarchy? And if so, what is it? Thank you.
Thank you so much, Aisha, for sticking to the 15 minutes. I'm sure that was very tough. You had there was a lot to say. Next, we will have Obioma opposing the motion. I'm sure we have a lot of questions and we can go through those during our Q&A. But for now, Obioma, please, you have the floor.
Thank you very much. Thanks, Aisha, for that formidable opening motion. Ladies and gentlemen, let's frame the debate as Aisha suggests, but let's frame the debate starting with legal principle. States can exercise their sovereign authority. There is no debate as to that. One expression of that right to exercise their sovereign authority is the right to limit what they can do in respect of foreign investment in specific circumstances. In other words, the bilateral investment treaties that many of our states on the continent have freely chosen to enter into with arbitration dispute resolution provisions are themselves an expression of our states' free exercise of their sovereign authority as a matter of international legal principle, not as a matter of moral thought, and not as a matter of policy campaign, as a matter of legal principle. And that is the starting point for this discussion. If we are to respect a valid expression of consent by states on the continent to be bound by international obligations vis-à-vis foreign investors, then we must look at the terms on which they agreed to be bound. That is a simple rule of law principle, and that is the starting point for the discussion. This debate is not about whether or not, as a matter of domestic law, states are free to pass regulatory measures or enact legislative measures. They can, there's no debate about that. The question is, what are the consequences, either as a matter of international law, if we're dealing with treaties, or domestic and or international law, if we're dealing with contracts? Now, I have four propositions. The first proposition is that the motion ignores basic principles of treaty interpretation in favor of aspirational policy arguments. The second is that it also ignores basic legal principles of contractual interpretation, and I'll come back to the importance of contract-based investment arbitration, again, in favor of policy arguments. And the final point is that it ignores viable alternatives, both in relation to treaty and contract investment claims, in favor of introducing an impressionistic and freestanding right to regulate, which has no basis in legal principle. Proposition number one, the motion requires us to ignore basic principles of treaty interpretation. Now, Aisha spent some time very eloquently discussing one view of the evolution of arbitral jurisprudence in relation to treaties, and specifically in relation to the FET standard. But there's an elephant in the room. The elephant in the room here, ladies and gentlemen, is expropriation. Expropriation requires a state not to expropriate an investment for legitimate reasons, non-discriminatory reasons, which may be made in accordance with due process, without making compensation. Let me put it differently. A state can still enact a measure which is for a legitimate public purpose, which is not discriminatory, which is made in accordance with due process of law, and as a matter of the express international commitments that states have undertaken embedded in international bilateral investment treaties, they are still required to make compensation. As a matter, I go back to my first point, as a natural expression of the exercise of their sovereign authority to enter into the bilateral investment treaty in the first place. This is not a question of balancing rights or not. This is simply a question of respecting the consent by a state to be bound to the extent to which that consent is validly expressed. Aisha has nothing to say on the expropriation point, because there is nothing that can be said to get away from the express language embedded in treaties. Either you uphold it or you do not. And I would respectfully suggest that that language should be upheld. Now, you will hear an answer, you've already heard it. Well, things have changed. 20 years ago is not the same as today. There's a new generation of investment arbitration treaties. Let's look at some of those, or at least one. The Morocco-Nigeria BIT rightly garnered quite a lot of discussion when it was first published. That bilateral investment treaty contains an express provision on the right to regulate. It also contains an express provision on investment and environmental protection. At the same time, for reasons that are not relevant to this debate, and which I don't actually know, both state parties decided to maintain an expropriation and compensation provision in the BIT. What does that provision provide? It provides, in very much the same way as the previous generation of BITs, that in the event that a measure is expropriates an investment, even though it's legitimate, even though it's non-discriminatory, even though it's made in accordance with due process, compensation must be made. There is no way to get around that unless we simply jettison all of the most fundamental principles of treaty interpretation out of the window. That is not what we should do. The second point is a similar point. It relates to contractual investment arbitration this time, and we shouldn't treat contractual investment arbitration on the continent as some sort of poor brother of its grander investment treaty sibling. We know, ICSID has published statistics on this, that African states regularly enter into contracts with foreign investors containing arbitration agreements. So this is an extremely important area. It cannot be neglected. And the Nigerians, at least among us, though I'm sure everyone listening to this will realize that indeed the PNID case was not an investment treaty case, it was a contractual case. So we cannot ignore what the principles applicable to contractual arbitration are. What is the legal basis on which it is said that a freestanding right to regulate, validly exercised as a matter of what may be public law in Kenya, in Nigeria, wherever, should not trigger compensation to a foreign investor where it amounts to a breach of a contractual obligation? I put it to you that there is no such blanket contractual rule, and certainly no such rule can be advanced in the absence of any consideration of what the applicable law might be, of what the law of the seat might be, or what the respective bargaining positions of the parties might be. Again, this is simply an attempt, with respect, to do away with the most basic legal principles common to all jurisdictions, pacta sunt servanda, in favor of a result that we may think is desirable. The danger of doing that is very serious, because once we start undermining basic legal principle, transparent legal principle, we don't know what will happen. This motion should be rejected also in the name of legal certainty. The final point that I want to make is that the motion ignores viable alternatives that are available to states, but that are consistent with legal principle, and that would not require arbitrators or states to seek to introduce a woolly concept of a right to regulate in order to rewrite obligations that they have previously entered into. They can renegotiate treaties, they can end they can denounce treaties. They can conclude treaties which do not contain arbitration provisions. They can conclude treaties which contain alternative dispute resolution mechanisms. In the contractual sphere, they can play around with the applicable law. They can reconsider what is arbitrable under the arbitral law of the seat governing the arbitration. They can, as Aisha says, consider whether or not the applicable law may incorporate elements of administrative or public law in order to legitimately introduce public law restraint on whatever the commercial bargain struck is. But what they cannot do is say there is a freestanding right to regulate, whatever the law, whatever the instrument. If we decide, or if whoever decides, that that freestanding right to regulate is valid, irrespective of the express commitments that we've entered into in the instrument, we're not going to pay you. One last point. Aisha mentioned whether or not some of these disputes are justiciable. The reality is they are justiciable under, assuming that the jurisdictional requirements under the treaty or the contract are met. So whether or not we would trust an arbitrator to rule on these issues is moot. What is important, however, is the uncertainty that would be generated, and here Aisha's making a point for my side, the uncertainty that will be generated if we allow a generic right to regulate, whatever that might mean, to be extended according to whatever jurisdiction says is a genuine public issue. There you will find that arbitrators, whether or not they are from the home jurisdiction or not, are being asked to decide matters of policy. And the motion which advocates for a blanket right to regulate or an extensive right to regulate across issues which haven't even been identified, but are broadly called public issues, will inevitably lead to greater uncertainty as arbitrators bring their subjective biases to bear. I'll leave it there.
Thank you so much, Obioma, and thank you again for keeping to the time. Before we move on to our rebuttals, we'll just give a moment to do the poll, just 1 or 2 moments for the audience poll. So obviously everyone's heard from Ms. Abdallah and Dr. Fuego, so you have a better understanding of what the motion is on if you didn't coming in. And so we'll just administer that poll where you can say whether you agree with the motion or disagree with the motion. Just give a minute for that. So yes, so that should be popping up on everyone's screens, and we will still have a moment for Q&As afterwards. But for now, we will just give a moment for the poll. So you should all have the poll question in front of you, which says a valid exercise of the state's right to regulate should not trigger compensations with foreign investors. Agree or disagree? And we as the panelists, myself, Ms. Abdallah, Dr. Fuego, we can't vote, so we're not skewering the statistics. And we'll just give that an additional minute. Hey, thank you so much for voting. And we will keep the announcement of the results afterwards, so keeping us on our seats and a reason to hang around. But before then, Ms. Abdallah, if you could just give us your rebuttal in a brief 5 minutes.
Thank you. I have to say that I think the case for compensation has been very, very well articulated. And I think my rebuttal is really to challenge some of the underlying structures that support this whole system of ISDS. The first is to say that as much as there might be measures that a state can take to withdraw from its bilateral investment treaties, these treaties have sunset clauses, which are usually at least 10 years long. South Africa has withdrawn from some, and it's going to take 10 years for them to feel the benefits of what it is they're trying to achieve, during which time, obviously, their citizens and residents will continue to suffer whatever adverse effects are trying to be avoided. So yes, there are things that can be done, but I think the reality is they are not quick. And certainly from a perspective of probably climate change, certainly they're not fast enough. There is, in fact, a chilling effect that has been felt across the developing world because of these investor state claims. And it's really regrettable because there's a whole industry and financing model that supports these claims. And unfortunately, even if you have the benefit of successfully defending, you're very much going to be out of pocket. So data shows us that the average cost of defending a claim at ICSID for a host state is $4 million US, a lot of which we could better spend in countries like Kenya, quite frankly, and that the average award in such cases by investors is between 20 million, which is the median, and 500 million, which is an average. So different types of ways of calculating what amounts are being awarded. Now, these are actually potentially peanuts in some countries, but actually have a very noticeable impact on the budget available to meet basic needs. And the mere threat that action could ensue because of regulatory action is sometimes sufficient to make a host state change its mind. For example, Indonesia banned open pit mining and then reversed it because there was a threat that they would face claims under international investment law. So I think we have to ask ourselves that, yes, as my opponent has said, host states can always regulate. All they have to face is potentially a risk of compensation. But that risk, it's so high and it's so disproportionate, and it has such an adverse impact on the overall budget available to meet other development needs. Is it actually tenable to keep open this prospect of compensation? And for those cases, we're not saying cases of indirect expropriation shouldn't result in compensation. We're saying that the interpretation of what that means is fundamentally skewed in favor of foreign investors, because it was a system designed to protect those that have against those that don't. And finally, I would just like to say that it is true that states exercise sovereign powers by entering into these agreements and treaties. But guys, we all live in this world. We can see that if you are the leader of the United States, you can simply, at the stroke of an executive order, you can rewrite everything. This is not an aspect of law. It's called real politics. We live in the real world, and it is true that when these negotiations take place, there's often a huge imbalance in host states who usually use the Attorney General's chambers to negotiate these and might not be that good at negotiating a balanced treaty, and very well-funded, well-paid teams of international law firms who are essentially advocating interests that are very much skewed in favor of the foreign investor. Faced with this prospect, it is only reasonable within the limited confines available to expand the wide margins of regulatory action, because anything else would require us to essentially become the leader of the free world and essentially write our laws by simply signing a bunch of executive orders. Unfortunately, this is not available to countries like Kenya. It is only available to a select few who can normally hire very expensive firms. Thank you.
Thank you so much, Ms. Abdallah. Before I introduce Dr. Fogo to give us his rebuttal, I would just let everyone know that this would now be an excellent time to put your questions in the Q&A chat box so that right after his rebuttal, we'll just go straight into our questions. Dr. Fogel, you have the floor.
Thank you. A few points only. The first one is that I heard a concession, which was that expropriation should give rise to compensation. So I think we're agreed on that point. The second point on regulatory chill. This is not a point that can be taken lightly. Nothing of what I have said should be taken as minimizing the importance of policy decisions and factors that may shape policy decisions, or indeed the absence of any policy decisions. The difficulty that we face is that we are lawyers, and specifically arbitral tribunals are required as part of their mandate to decide on the claims brought to them. They cannot simply say, we're going to decide this purely on a matter of policy. They have to identify transparent legal principle and apply legal principle as part of the rule of law. Now, leading in, therefore, to the point on regulatory chill, it is undeniably true that governments are increasingly having regard to the threat of international litigation before they introduce regulatory measures. As a matter of principle, general principle, there is nothing intrinsically wrong with a government considering the potential effects of a domestic measure that it may be contemplating as a matter of its international law commitments. Indeed, one would hope that they do that not only in relation to international investment law, but also across the piece. Again, it's difficult to get round the consistent application of principle of the sovereign exercise of authority, of legislative authority. Often these treaties are ratified by whatever parliament might be in question, simply by saying, it's regrettable, we all know how this works, this is real politic, and so on and so forth. It may be that that's the answer that the tribunal wants to give, but it's going to have to try to come up with a consistent legal principle to do so if we want to retain the system. We can't have it both ways. The last point is on climate change. So it was said a number of times that the Paris Agreement establishes higher commitments as a matter of international law than those contained in bilateral investment treaties between two states. I wouldn't accept that as a proposition, but in any event, it is perfectly open to states now to consider the interaction between the Paris Agreement and whatever investment agreements they want to conclude, as indeed the Morocco-Nigeria bit does, and I'm sure other BITs do. But we shouldn't lose in all of this if we're insisting on the reality principle, that oftentimes foreign investment is made in relation to projects that are actually helpful, that can bring something. It is not uniformly the case that a foreign investor who wishes to invest in a state on the continent is seeking to do so rapaciously or somehow underhandedly. And I think we should resist the temptation to conclude that that is the case, and therefore that any regulatory action amounting to expropriation or unfair treatment is somehow legitimate.
Thank you so much. Again, thank you so much to both of you for keeping as close to the time as possible. I know that that's not always easy. And I will also say, having seen the poll results, that it's quite close, just a few percentage away from each other. But I will announce what those results are after the Q&A session and after we do the second poll. We have some questions for you both. So I will ask a question and then you both will have an opportunity to answer. So the question we have is from Advite. I hope I'm pronouncing that right. A student member at the newly established CITICA, Chair on Investment Treaties and International Commercial Arbitration, Delhi. So their question pertains to what can be done to address the system as it stands from the perspective of the developing world. And I know that Aisha spoke a lot about the developing world, as it were, which a lot of African countries find themselves classed in. So the question is, out of the top 5 economies, only India has ever lost an investor state claim. So what can be done to beef up the developing world's capacity in such dispute resolution? I think that's a bit wider than what we're talking about, but luckily we have some arbitration experts, as I've been calling them, with us. And so I think you're both able to answer that. Aisha, I will throw that question to you first. What can be done to beef up the developing world's capacity in investor state claims?
Okay, thank you. I think the first thing to say is, unfortunately, we're playing catch up and we remain subject to very badly negotiated and badly drafted bilateral investment treaties. A lot of the ones that apply in Kenya, which has a whole bunch of them, are very old and I think don't actually reflect modern views, including even reasonable views like my opponents about what is reasonable in this day and age. So as much as we can work to improve our negotiating capability, we have to understand that that will not get us out of claims because a lot of investments are already in place under previous treaties, and those treaties were very one-sided. Now, there's a whole bunch of stuff which is being done. Some there are efforts to actually capacity build to improve the ability of attorney generals, lawyers in negotiating these, what are essentially commercial bargaining agreements, and are often very long term and require some understanding of industry sectors. So they're not just legal. Somebody would have to understand, for example, pricing in the electricity market in great detail in order to probably come up with a reasonable compromise if you're an off-taker of electricity. So it's not enough to have the legal skills. We also need a lot of technical capacity building, and we need sector capacity building. The other thing is, I think that as a continent, there have been various measures. So I know that one of the things is under the African Investment Protocol. It actually codifies the right to regulate. And this is there just to sort of make it clear that they're not seeking to interfere with that. Of course, and it also replaces what is called the fair and equitable standard with something called fair administrative and judicial treatment. So I'm not sure if it's the same thing, because quite honestly, we're going to have to fight about it to understand. But I think it's a move towards making it slightly friendlier for host nations. And then we're still waiting for the dispute settlement mechanism, but it seems quite clear that politically no one is very interested in investor-state dispute settlement for Africa. And so what can be done? I think that, of course, there is a backlash when states try to terminate some of the historic treatments. And I know there was a lot of backlash against South Africa when it went through this process. It terminated all of its bilateral investment treaties, and they have the sunset clause, which is still running. But in the meantime, a lot of foreign investors withdrew funds, and of course, a lot of people were skeptical. So I think I come back to something which I'm not sure is solvable legally, which is that regardless of what the law provides and what is negotiated on paper, I think we all have to remind ourselves, many of these investments are huge in size and dwarf national budgets. I mean, these foreign investors who come to South America and Africa, they behave as if they're the equivalent of our host state in terms of bargaining power, in terms of capacity, in terms of technical expertise. And often there is this natural imbalance. So I don't want us to think that it is an easy thing to solve. I think the fact of this debate demonstrated it's difficult. Even when you're trying to do what you think is the right thing, it's difficult. I just wanted to say there are some things that can be done, but remember, they are forward-looking. They don't solve the existing exposure you have under the treaties, and even if you terminate them, they're not going to solve them for a long time. So unfortunately, we can do more, but let us be realistic.
Thank you so much. Dr. Fuego, I know that you operate from Paris, which is by no standard considered the developing world, but do you have anything to add
Depends
about
on
how
the viewpoint.
developing? Depends on the definition. But anything to add about how the developing world can beef up its capacity in investment, in respect of investment state claims and disputes?
Yes. I spend a lot of time also in South America, and Brazil is an interesting example. Brazil's had a policy, and a policy of not entering into investment treaty disputes with arbitration provisions. It is not suggested, Brazil's obviously a huge economy, it's not suggested for a second that Brazil has suffered huge deficits in the incoming foreign investment as a result of the decision not to establish lots of bilateral investment treaties with lots of different states. The lesson I take from that, I'm not sure how considered that policy was at the time, but the lesson I take from that is that the policy needs to be broad. It needs to be coherent. It needs to be joined up. So even before we start talking about negotiation of bilateral investment treaties, we need to think about whether or not this makes any sense. I know that that ship has probably sailed on the continent, but that's obviously ideally what would be done. There are political instability issues and changes of government and that sort of thing which need to be navigated, but that's the starting point. The next point is exactly as Aisha said, I would have thought, which is that you need to find a way to build expertise, knowledge of the way this pretty esoteric system actually works amongst highly skilled lawyers, public lawyers who might not have seen the system. And not just investment arbitration, but contract-based arbitration, because often if you have contract-based arbitration, you want to challenge an award, you need to be aware of what the time limits for doing so are in the seat of the arbitration. It's something we saw with Nigeria in the P&ID case, but it will happen all the time. I know that, India, for example, it often you see whatever you see of the public awards, they're often PCA cases, UNCITRAL rules, so it's probably going to be a localized seat. You need to have lawyers who understand the importance, lawyers working for the Indian federal government who understand the importance of a seat and what that might mean. And so you need to get people on board. And that's probably going to be a collaboration between the private sector and government, the way it can be done. In terms of, just the last point, in terms of how to deal with existing BITs, which are not favorably worded. This is a sort of the flip side of the regulatory chill point. It is, I think, helpful for lawmakers and specifically drafters of legislation to think how they can frame regulatory or legislative measures that may have an adverse impact on existing foreign investment, at least so that that provides some sort of hook for counsel once they're coming to legitimate expectations arguments and discussing proportionality and that sort of thing. And you'll see that all of the Western European countries do it all the time in the way that they frame it. They might not be successful, but at least they do it to give government a credible chance to fight off some of these FET claims.
Thank you so much. We have a few questions, so I would say if we can give answers as brief as possible. I know we have two for Dr. Fuego and then one for the both of you. So the first one, also from Advait Arunav, who had asked the previous question, is that with respect to your rebuttal, Dr. Fuego, if indeed investment has such general benefits, can that really be the focal point of this discussion, considering the sidelining of the fourth prong of the saline test?
I wouldn't say that I'm confident saying that investment has a general benefit. All I said, I think, was we shouldn't be too quick to assume that all foreign investment is for malign purposes. So in considering this debate and coming to this debate, if we're going to adopt a personal view as to the benefits of investment or not, it needs to be a balanced one and needs to be informed by what the actual project in question is.
Thank you so much. And a question still for you from Victor Mana. If a host state exercises its inherent right to regulate and does so cautiously and cognizant of all available safeguards, the valid exercise, what entitles an investor to automatic compensation? yet the investor is expected to preempt and prepare for such regulation and do so as evidenced by stability requirements and clauses?
Depends on the nature of the claim. If the claim is an ex-pro claim, typically what that means is that the investor has been deprived of the substantial benefit of its investment. So that's why it doesn't matter whether or not the purpose is legitimate or whether the decision was made in accordance with due process. What is looked at is the effect on the investment. It's gone from being 100% investment to being zero, effectively. And in those circumstances, you have to say, well, why should the investor that has received this, that is the beneficiary of this express commitment, not benefit from it? The situation in FET claims or analogous claims will be different, of course. There you are indeed considering the legitimate expectations of the investor at the time the investment was made, whether or not the regulation is proportionate, and so on and so forth.
Okay, and our last audience question before I ask both of you a question as well. Our last audience question is from Uzozi Ofuego, and I will direct that to both of you. So who determines when and why to withdraw from an agreement in situations where the government in power isn't legitimate? So Aisha, I will let you answer that first, and then we'll go to Obioma.
Okay, so these are some of the many conundrums of this issue. The exercise of sovereignty in the first place to enter into the agreement and contracts. Often you will find some people saying that some of that was procured maybe by corruption, or that particular government didn't have the legitimacy in the first place to enter into those agreements. But I don't think that takes us very far. It's very circular by law, because we have to assume treaties are binding. Otherwise, I don't think we have jobs. We do want to keep our jobs as lawyers. And then somebody comes along later, they're elected, maybe they're from the opposition and they win, and it's like a bit like President Trump. And then they just undo everything because they had taken a stance in terms of their campaigning that said, if we come into power, we're, discontinuing these relationships, these agreements, we think they're unfair. So I think these are not legal issues. For me, this is pure politics. And I think it very much depends on whether you personally align with the policy stance taken by a specific government or not. I don't think this is legal. I think you can argue it personally. I think you can argue it either way. And I think even if you are a despot, your ability to confer a concession, it must be respected. Because if you're a despot and no one can operate in your country without your say-so, I don't think it matters that you're very unpopular. Presumably, you have the ability and legal right to confer the concession, and then somebody else might come along later and withdraw it. All I'm saying is, I think this is one of those problematic debates where you have an intersection between law and politics and economics, and it's not very easy to unpick. Whichever side you're on, there will be aspects that you can't control, and those are the non-legal aspects for me. So that's my loyally without prejudice answer.
I guess that that intersection of issues between the law and politics and almost philosophy, if you will, is what happens when we're talking about the rights of states. Obioma, anything to add about who determines when and why to withdraw from an agreement in situations where the government in power isn't legitimate?
Yes, I think that I agree with Aisha. It will be, I know that at least in certain jurisdictions, the issue of law is decided by reference to whatever the official policy of the government is. So if the government says, this is the foreign government that we recognize, then as a matter of law, that is the position that has to be followed. Those are the jurisdictions I'm most familiar with, and we've seen a lot of that with relation to the Venezuela litigation, for example, in the last couple of years.
I guess, simply put, we work with what we have. Until we don't have it anymore. So those are the audience questions that we had. And then I just wanted to ask both of you a question as well. So my first question is to Aisha. Under customary international law, states are required to compensate for wrongs. how do we then reconcile this with your position, especially for treaty claims where the treaties do not modify this CIL rule for its breaches?
Well, it's because my argument philosophically is that that customary law position was developed by colonizing nations for the benefit of their nationals investing in developing countries. And if you think that is correct, you could understand why I'm not that fussed about moving away from what I consider an inherently biased system. If these systems had come out indigenously from the African continent, I think there would be a completely different argument. But I am essentially saying you're being faced with this historical injustice. I'm going to be quite robust in my wording. And therefore, the very few mechanisms available, there are very few. You will always face claims. Some are undeserved, some are deserved because they're expropriation, direct or indirect. But some will not be deserved, and you will never be compensated for what it costs you to defend them. And inherently, that seems to me unfair.
Understood. And I hope I'm not showing any bias to say I agree on the use of the phrasing of historical injustice. And so my question to Obioma before we then go on to our final poll, our closing remarks, addresses from you both and closing remarks from LACIAC. Obioma, with the prevalence of political risk insurance, can states now agree to exclude the right of compensation to investors for breach of treaties, or does this eliminate the PRI business given how subrogation works?
Wow. My usual position is just that states can do what they want to do.
We work with what we have.
You work with what you have, but also if you don't have anything or you have the opportunity to change it, there's no reason to not to do so. I mean, investor-state, joining up with what Aisha said a moment ago, investor-state dispute treaty arbitration is not a destiny. It's supposed to serve the purpose of justice. If it doesn't do that, there's no reason as to why it has to continue to exist. States can, yeah, they should do what they want to do within the law.
Thank you so much. And I think that our personal opinions are starting to show as we round down. I think at this point, I will just give a few moments for our second poll. In case, actually, I think I will change it around a little bit. And before we have our second poll, I will actually ask you both for your final address. So Aisha Obioma, is there anything about on the motion topic that you want to say that maybe did not align with, you couldn't say because it didn't align with the position that you were assigned? Or I think, have we been thorough in our questions and in giving you the opportunity to answer those questions? Is there anything else you would like to add?
Aisha?
Thank you. You are right when I think I tried to make clear from the opening that cases of expropriation, direct and indirect, should be compensated. I think we differ on what the meaning of expropriation means and how you apply various cases to interpret it. But I think there are some real clear cases where a state just comes in and takes over a very profitable operation and takes it for itself. And that has happened, and that is wrong. And I think all of us at a basic level, whether or not you're a lawyer, would recognize that there should be a remedy. I'm just saying that often we're in the middle and it's very gray. And I don't think personally, I don't think that privately appointed people actually have the legitimacy to make those gray decisions. I think that's my final.
Thank you so much. And Obioma, any final words on the motion?
It's important to keep in mind that this should not just be a strict black letter law discussion. I think that's, if it probably may not have been obvious from what I was saying, but certainly all of the political and historical considerations, particularly in relation to the continent, but also elsewhere, are key to the discussion of investment arbitration, and no sensible discussion can take place now without taking those factors fully into account.
Thank you so much. And so I will give an opportunity for the second poll. It's going to be the same question, but just to see if anyone's opinions have shifted, having had the opportunity to hear the debate in full, having had the opportunity to ask questions, hear them answered, and also hearing the final address from both of our debaters. So we'll just put the poll up now for about a minute or two. Okay, so while people are answering that poll, although I hope this will not bias people one way or another, like, let me just give it a moment before, because as a lawyer, I am hyper conscious about creating bias. So what I will say is the first poll that we did, which was right after both of you had an opportunity to open your positions, it was pretty tight. 48% of people agreed with the proposition that a valid exercise of the state's right to regulate should not trigger compensation to foreign investors. So 48% agreed, and 52% disagreed. So pretty tight. If this was an election, it would be, I think the loser would feel pretty good about themselves. But yes, so 48% agreed with the motion and 51% disagreed, or 52% rather. And so looking at it now, where we have, I think about the same, yes, so the same number of people answering the poll as we did last time, and now 55% agree that a valid exercise of the state's right to regulate should not trigger compensation. So that's turned on its head from 48, and 45% disagree that a valid exercise of the state's right to regulate should not trigger compensation to foreign investors. So beforehand, more people disagreed that a valid exercise should not trigger compensation, and now more people agree that a valid exercise of the right should not trigger compensation. But I think all in all, it's still pretty tight. The difference before was about 4% or so. Math is not my strongest suit, 4%. And now the difference is about 10%. So really close. Thank you so much for everyone joining. And thank you so much, Aisha and Abdul, Aisha and Obioma. And before we leave, I will just give some closing remarks on LACIAC and on some of the events that we expect to be coming up. So I have did a very interesting and insightful debate. I hope that all of us on this platform have thought the same as well. I commend both Aisha and Obioma for giving up their time, their very busy time, to be with us here today. Just a brief summary on who we are as LACIAC and what we do. I wanted to keep this till the end, where we'd have as many people on as possible. So the Lagos Chamber of Commerce International Arbitration Center is an independent full-service arbitration and alternative dispute resolution center affiliated with the Lagos Chamber of Commerce and Industry, with a focus on fair and efficient alternative dispute resolution in Africa. Recognizing Lagos's potential, the center aims to put Lagos on the map as a reliable, efficient, and transparent hub for international arbitration. Native to Nigeria, LACIAC is aware of the challenges faced and aims to provide a viable and user-friendly alternative to traditional litigation, offering a full service of ADR solutions, including arbitration, mediation, and conciliation. I would also like to use this opportunity to invite those of you as the audience to take part in some of our other initiatives. Specifically, we have an upcoming international trade conference that's going to be a hybrid event taking place physically in Victoria Island, Lagos, and also virtually on Zoom. And that's going to take place Thursday, March 27. The event's theme is Trade for Prosperity, Unlocking Economic Opportunities Through the African Continental Free Trade Area. We urge you to follow us on LinkedIn to ensure that you're up to date on all our events and initiatives, which will include the 10th edition of the debate, which will take place sometime in Q2. Q2 is almost upon us. And we thank you all for attending, and we look forward to having you join us again for the next edition of the debate. And again, thank you so much to Aisha. Thank you so much to Obioma as well. And that brings us to the end of the debate, everyone. Thank you so much for joining. Bye, everyone.